But the judge was concerned about the contentious nature of the jury, and he released the jury.
And he called a mistrial, released the jury, called a mistrial, and that's where this sort of becomes a groundbreaking case that goes all the way to the Supreme Court.
He initially asked for input from both the prosecution and myself as to our take on his consideration for that. I said there were other remedies. Poll the juror, give an Allen charge, which is instructing them to act properly, to consider other people's thoughts, to put into mind all those things. There's certain things to do when the jury is having trouble reaching a decision. And then the prosecution was, well, we think it's all done. We think they're not making any progress at all. We believe it's reflective of what we all knew. The judge, as I've said in an earlier segment, the judge is entitled to great deference. And that's the Superior Court, the Georgia Supreme Court defers to the judge in Superior Court in many cases because the judge in Superior Court is sitting there at the trial court, listening to the evidence, seeing the inflection, hearing how people are talking, looking at their faces. He knows more, and that's why he's entitled to the deference in order to defer to him. And so, in the same way, you can tell by what we're saying, we believe it's going not guilty. And you can tell by what the district attorney is saying that they believe it's going not guilty. Because the indication is they want to get out as soon as possible, and we want this to continue and try to get these people to deliberate until they get to a result. Because if they had gotten to that result and it was not guilty, it was right at 10-2, and the indications were that meant not guilty. And if that had continued on, we believe he would have walked out that day, or come back on Monday if they didn't finish that day, come back another day to continue deliberations. But eventually they would have gotten to a not guilty verdict, and he would have walked out September of 2015, rather than whenever he's going to get out, now that we've got the judgment back from Monday, waiting on a remediature of the court so that he can be released.
And it's that point that brings us to double jeopardy in the Constitution, which is why it went all the way up to the state Supreme Court, Jay. Some of the, you really touched on the important pieces that you were arguing in front of the Supreme Court justices, and their verdict was, overwhelming in your favor.
We were so happy. You never know. You never know. We felt very solidly.
You felt good about it.
That we were on the right track. The questions from the justices, which can be viewed on the Georgia Supreme Court website under court info and go down to archived, archived oral arguments, so you can always go and see that.
You can go and see,
But anyway, so the questions that they were asking were appropriate and indicative that they were agreeing with us, that there has to be something else. When the prosecution asks for a mistrial, they've got to have a really, really, really good reason for a mistrial. But when the judge does it because it's necessary, that's fine. We'll defer to the judge. But if you're going to do it on a reason, you've got to the record's got to support that reason. You're not entitled to total deference. They're not going to totally defer. And as we said, the one juror that was dismissed is not a part of the 12. So what she thought, felt, or anything is not even relevant.
Doesn't even matter.
And from a legal standpoint, in our view, it's not relevant. The fact that they were having trouble coming to a decision is totally normal for a jury. And that happens in virtually every case for some period of time before the jury winds up they just all finally agree. And that's the way jury verdicts work. And then we strongly, and I, in many of these It's the Law episodes, have argued over too much that law enforcement is deferred to. And if we allow a law enforcement officer through a bailiff standing outside the door of a jury room to have significant input into a jury being released and a mistrial being declared, we've lost it. The rights of the jury, and I'm not saying in this case, but I'm saying that setup will be abused. It will be abused by both prosecutors and law enforcement officers and bailiffs. It's just the nature of the case. It will be abused if that's allowed to stand, and we are so glad that we got that stopped.
Let's talk about what is next for Jadarius Meadows.
Well, Jadarius Meadows, on the time that he was released for a period of time on bond, he did finish his high school diploma. So I believe he was in the Lane Lucas program, and some things have worked out very well for him. He's looking at possibilities of continuing school. He was an honor student during the time he was in school. The events of this may have been some bad associations. The charges came about because he was earlier in the day associated with one of the known people who participated in this crime. So the truth is that he has two choices, because in our community, in his community that he lives in, coming out of this gives a lot of street credit. And he's going to have two choices. That this gives him a fresh start on a new life and lets him have a second chance at life and move forward and continue his education and continue the things that he wants to do, or if he lets it get him into a society and continuing associating with other people. So we hope and pray he chooses the first of that, and that he moves on. But we think he's a bright candidate for the university and for different programs there and that kind of thing. So we're hoping that things will go. But we're absolutely happy that the Constitution is upheld, that this was not allowed to stand in the way it was going to be in order to retry. When a jury is impaneled, chosen by both prosecution and defense, and it's put into effect, and it's listened to all the evidence the state has to offer, and after hearing all the evidence has to offer, they need to make progress unless there's some, as the law provides, it's manifest necessity. It has to be something that is so strong. It's not accurately defined exactly what it is, but it needs to be something so strong that there's not any good reasonable alternative but to end that trial. That's the only way in this state and hopefully this country that somebody could be retried in a situation such as this.
Yeah.
That jury should have completed their task.
Boy, you put a lot of work in that trial, Jay, in that entire case, man. Well done. We're going to attach some links to the oral arguments at the Supreme Court, to this interview. You can see Jay again, of course, at James W. Davis and Associates, basically around the clock. And, of course, Wednesday nights during our 6 o'clock show during It's the Law. Jay, appreciate it.
Thank you.